I'd like to bring in from London, who's been patiently waiting, Patrick Henningsen. Patrick, I see you there. He's the editor of 21st Century Wire, and he was outside the courtroom today, and he's going to tell us what he saw. Patrick, welcome to the Vigil.
Yeah, thank you, Joe. Good to be with you.
So please tell our viewers what you experienced today when you went down to the magistrate's court.
Sure. Yeah, the courtroom, the whole problem with changing the location of the courtroom from a larger or a main courtroom to a small courtroom, where practically no members of the public were being allowed into what's called the public gallery. And in terms of the press access, a very limited space for press. I'm an accredited journalist, and I wasn't allowed in, as were many other journalists. Accredited journalists weren't allowed in, so there was limited space. And the question was, why was that? The huge crowd turned out in terms of public. I'd say hundreds. There was at least 300 or so or more supporters outside, plus the press pool was massive. There's probably at least 20 or 30 mainstream media organizations, plus a few dozen alternative media outlets as well outside. And so why was it restricted so much? And the excuse given by the administrators at the Westminster Magistrate Court was that the smaller courtroom had a video link. Therefore, it was the only one that they could use. So, this brings up two kind of fundamental questions. One, why was Julian Assange, only appearing via video link, as a terrorist would, for instance, someone in a maximum security prison? Why wasn't he there in person? Because reportedly he was at Southern Crown Court only yesterday in the flesh. So one has to kind of guess maybe this was to. And by the way, the hearing at Southern Crown Court yesterday in Southeast London, that was moved up from May 26th to May 1st at the very last minute. It was just announced only a day or two before, April 29th or something like that. So nobody was able to know. So the public couldn't mobilize for that event. And so I think this was a political decision, to have him appearing via video link on this particular hearing today. So that's the one thing. The other thing is, of course, they could organize a flat screen TV and a link. I'm sure they're capable of doing this in the main courtroom. So this was the excuse given. So it seems to me, Joe, that this was sort of arranged in order to have the least amount of public support there in the courtroom, and also the least amount of press being given access to this event. But, from a public support point of view, it was huge support outside. It was great show of support. A number of Gilets jaunes, yellow vests as well, came from Paris to show their solidarity. There are people from numerous European countries who came to show support outside the Westminster Magistrates Court today for this extradition hearing, which is the first move in a sort of potentially a long process, which you've already laid out there. There was also 150 or so people outside of the courtroom, inside of the foyer, up on the mezzanine level outside of this court. So it was a huge amount of supporters there. And I don't know if that would have had any bearing, of course, in the proceedings, but certainly in terms of public optics, this can't be ignored from the sort of judiciary side, the British government side, but also from the media side, the press side as well. So they really sucked the dramatic oxygen out of the sort of the courtroom hearing of what is the beginning of a monumentous international legal proceeding here. I mean, this is historic, this legal proceeding, even though this was just the first salvo, the first move in a long process. But to deny that from the press at large, and to deny that from the huge public. I mean, this isn't just any case. This isn't just any. This has huge public interest ramifications in terms of freedom of the press, which is a fundamental pillar or building block of British society, European society, post-Enlightenment, democratic civilization. In fact, that's not an over-dramatization. In the United States, North America, every country in the world that's fought so hard to achieve some protection and press freedom in modern times. So that's what this case kind of represents. So to deny that to the public, to the press at large, I think is very telling.
Okay. Patrick, were you able to follow the proceedings on a TV screen? Did you hear what was going on inside?
No, we weren't. But on May 1st at Southern Crown Court for the bail jump hearing, people were allowed access into a sort of a closed circuit TV video room to sort of see the proceedings there. This is what we've understood just from talking to people who attended it. That facility was not available at Westminster Magistrates Court. That sort of luxury was not.
I see. So you're making the point that had he been allowed to come in person, they could have stayed in the larger courtroom. That
Absolutely.
They wouldn't have needed this video link. So you have no idea. You're also relying, like I am, not in the UK, about what happened inside, just the reporting. And I quoted from the London Daily Express. I mean, I didn't want to do that, but we didn't have access to this. But it only lasted 10 minutes. I would love to get the full statement if it comes out of what Julian said. That quote is a tremendous one. I refuse to surrender to the U.S. for practicing journalism. That's won many awards and protected many people. That's a great quote, but I think he may have said more than that. But now your point here about the supporters coming from all over and backed up by this poll that I mentioned, I think sections of the public are getting it. And what they're getting is something that really interesting. I watched this week an interview that Julian gave in 2010 to the 60 Minutes program in the US. It was a long interview. He was at that time under house arrest in Britain, wearing an ankle bracelet. And it's an excellent interview, and I recommend people see that. It's easy to find online. And one thing he said was, it's extremely relevant because they're talking about the Espionage Act. They're talking about the U.S. indicting and arresting him. They're talking about him being extradited. And most importantly, Julian says that if the U.S. goes down that road, if they do all these things to me, they have crossed over to a dark side, basically. I'm totally paraphrasing here, but they are no longer the United States of America. At one point, Steve Croft, the interviewer, says, people say you're anti-American. And he said, no, on the contrary. We are supporting the ideals of the United States, of Jefferson, of Madison, etc. But if the U.S. indicts and extradites me, a publisher and a journalist, they will have changed as a nation. It was something dramatic to that effect. And you can't be overly dramatic about that. This is absolutely the case. As I've said, this is a defining moment in the history of press freedom. It will be studied for decades after this, whatever happens, because they are taking a quantum leap over this red line that criminalizes journalism, that the Obama administration, for all its faults in arresting and prosecuting more whistleblowers and all U.S. administrations previously, they did not indict Julian Assange because they knew what this meant. When the Trump administration, and we see what they're openly doing in Venezuela, for example, that they also announced this week that the troops are staying in Syria indefinitely, even though Trump has twice announced they would leave. All the typical interventionist and imperial policies that are being continued, that all administrations continue. This one is no less aggressive than any of the others, but they've added to that this attack on the press in the person of Julian Assange. Talk a little bit about that, Patrick, about what this means to you as a journalist.
The British government is reviewing the possibility of passing legislation that would criminalize publishing information that's already in the public domain, from 2 to 14 years in prison. Okay. Now, this has been protected. This has been, leaking is one thing, certainly in terms of the Official Secrets Act. But once something's out in the public domain, to republish it or to sort of, as a journalist, imagine the implications of this. And so this looks like it's custom made for a WikiLeaks situation. And the point I want to make is this is also above all, as well as being a journalist and a free press issue, how this problem has come to pass for the state in terms of maintaining the powers that it wants to accrue in terms of controlling information, mitigating any potential embarrassments. So this is effectively a technological issue that has emerged with the rise of digital technology and the internet. So this is a technological issue combined with a jurisdictional issue. And WikiLeaks is the quintessential 21st century media outlet, very different from normal, or to quote, normal other mainstream media outlets, in that it does what it does in a very pure sense. From that point of view, publishing information, WikiLeaks does the heavy lifting. It takes the risks. It protects the whistleblowers. The rest of the mainstream media should look at that and say, what a great service they're providing, much like a newswire service, but a lot more deep and valuable in the sense of leaking stuff in the public interest. They should be, rushing to the defense of WikiLeaks and saying, what a great service. They do all this hard work for us. They do it for free. And all we have to do is go in and do the investigations and find out what's relevant in terms of the data that's been dumped, cables, emails, etc. Okay, that's not happening. Why is that? That's an interesting question. It's not just political. I'm gonna contend that this is also what WikiLeaks is challenging, the business model of the legacy media, the paid exclusives. And as you know, Joe, and as many other people, they honestly know about how this system works. Not all paid exclusives get published. Look at the Murdoch press. This is used to bury stories as well. This is the business model, the sordid business model of mainstream media as well, the legacy media. So WikiLeaks challenges this because it does this for free. It puts this out. There's no money exchanged with the sources. This is, in its purest sense, journalism, you could argue, right? And so this flies in the face of a monolithic press that has been co-opted by the national security state, been co-opted by the corporate state, whereby a lot of information ends up locked in filing cabinets in mainstream media organizations over the years, or buried or disappeared, or ended up locked in archives and warehouses and things like this for years and years. But WikiLeaks challenges that directly. But just on the direct threat question, I'll just say this, Joe, that Julian Assange didn't set out to be this person, and certainly Chelsea Manning, knew the risks of what she was going to do. But both Julian and Chelsea Manning are holding a very, very important line for so many people, not just journalists and media outlets, but citizen journalists, of which there are thousands and thousands more coming online every month. People who use Twitter are doing forensic document examinations and presenting things as individual citizens. And this affects them too. So there are people who are doing journalistic work who don't maybe classify themselves as journalists, maybe as enthusiasts or activists. They're also they would be implicated in this new sort of super legal structure, this universal jurisdiction that the United States is projecting and hoping to sort of enforce. And with the extradition lawfare, spurious lawfare games that you just laid out, Joe, with regards to Ecuador, in this three-way collusion between the United States, the UK, and Ecuador. Think about that in terms of the long arm of the United States, and it'll threaten countries with sanctions, for instance, if they don't give up this person or that person. So there's no escape. There's only a few countries that that could withstand that type of pressure, diplomatically, economically, and so forth. And so the United States is acting like it's running this kind of international racketeering That's not a exaggeration. Look at Ecuador banking a $4.2 billion IMF loan, which clearly was a quid pro quo arrangement, and there's another $6 billion in the pipeline. And you look at what they've done, fast track, just bypassed international law, Ecuadorian law. The British, by fault, they're taking that by fault. The British are flouting international law just by participating in that.
I worked for years for the Murdoch Press, both the Wall Street Journal and the Sunday Times over there in London. And I could tell you, yes, they buried stories that I pitched to them, and I'm sure I wasn't the only one. So that is the routine way in which the corporate media shapes a narrative that's friendly to establishment interest, which is more to omit and suppress news than to actual fabricate it. But this law, I was unaware of what you said Annie was talking about last night. Can you tell us a little bit more, because a lot of Americans don't know about the Official Secrets Act, and what we have is the Espionage Act, and there's that Section E that says that anyone who has possession of unauthorized classified material, and anyone who disseminates that can be prosecuted. That's about as close as we get to the Official Secrets Act. What we've got in the U.S., of course, is the First Amendment, which is different because that's about what's called prior restraint. The government cannot order a newspaper or any news organization not to publish something. But once it's published, and this was established in the Pentagon Papers case, once it's published, they can prosecute. So Julian, no one denies it, and Julian himself would not deny that he had possession of classified material and that he published it. That should be obviously protected by the First Amendment, but it is not. And therefore, this law, a very bad one, is on the books, but is never used by any U.S. administration, but might be by this awful Trump administration. So that is the closest we have to an Official Secrets Act. Can you lay out for the listeners what the Official Secret Act actually does and how it impacts the press in Britain, and again, what this new law would entail? I mean, the idea that something that's already in the public domain, this is extraordinary.
Sure. There's probably people who can give a better commentary on the Official Secrets Act than myself. I am familiar with it. Effectively, what is the Official Secrets Act? It's a kind of a gagging order that's always there. It's always in the background for anybody who works for a government agency, who works for the state, who has any level of clearance, would fall under the purview of the Official Secrets Act. So it's really a deterrent for whistleblowers in the UK. So, anything they talk about, if it's deemed to compromise national security, but maybe not even just national security anymore, Joe, because that word has been stretched out. It's so elastic now. The other term that has come in to play with the press with regards to D-notices, which you may or may not be familiar with, but I'm sure you are. The D-notices, if they come into collision with the national interest, not just national security, but the national interest. So a D-notice is effectively a kind of a voluntary censorship regime which exists between the government and the mainstream media, whereby if a story sort of appears, certainly the Alan Rusbridger at The Guardian was one of the sort of last cases where it sort of went against that with regards to the Snowden story, but also the WikiLeaks stories before. So they would then have this kind of line of communication with the state agencies to say whether this is potentially a threat to, I mean, that's real press control of the state. That's what exists in Britain. And it's a voluntary regime, but everybody kind of plays ball with that. Certainly the big media outlets. So nothing really, very careful what they report, and if it falls foul of the D-notice. So anything could go under the D-notice. Certainly the Skripal poisoning event in 2018, there was a D-notice issued immediately on a gentleman named Pablo Miller, an intelligence operative, who was also the handler, as it were, of Sergei Skripal. So that went out and was disseminated through mainstream media outlets. So no talk about Pablo Miller, so you'll never hear about this person in their sort of work with Orbis intelligence, for instance, that was also involved with generating the Steele dossier, staffed with ex-heads of MI5, including Richard Dearlove and many other former agents, as it were. So the Official Secrets Act, if they expand this and review this, which according to Annie's analysis last night, which is also available on RT UK's Facebook page on that live stream, Annie laid out this, they're reviewing the Official Secrets Act, wanting to expand the remit of it to, and also the prohibition of the publication or possession, as it were, of classified material. But that's, could it go from classified to threatening of national security? I mean, it seems to me like we're moving into a time where a lot of these boundaries are totally fungible now, because of political reasons or political pressure that's put to bear, or a cartel of countries like NATO member states, for instance, operating under a sort of a Five Eyes framework already, that they would say, well, yeah, it's not just classified material, it's something that could threaten national security or the national security of NATO members collectively. Theresa May has already put out dictates with regards to total coordination in terms of public statements made for any sensitive national security issue. This is called the Rapid Reaction or Rapid Response Mechanism. This was announced at, I believe it was the G7 meeting last June, that every G7 member has to be on the same page with anything with regards to Russia or any serious national security incident in terms of their response publicly. All the governments will be exactly on the same page. And I think if you look at statements by Emmanuel Macron, by the US leadership, by Britain, by other NATO member states, that's pretty much in effect, especially over the last sort of year or so. So this total coordination is not only a US issue, it's not just a British issue, but it's also kind of reflected in the kind of the NATO framework as well. So again, that's going to make this universal jurisdiction that the United States looks like it's kind of leading that sort of operation in terms of enforcing and punishing individuals or organizations, or countries internationally. This seems to be a cartel. That's the best way I can maybe describe it.